From North Carolina, Mr. Bishop.
Thank you, Mr. Chairman. Ms. Khan, is this working? Doesn't sound, yeah, I guess I hear it. Someone pointed out to me that just this morning the FTC, well, it was disclosed the FTC sent a civil investigative demand to OpenAI. Are you familiar with that?
Congressman, this involves non-public information, but if it's been publicly reported, then it may be accurate. But I'm hesitant to share anything non-public in this.
It's on Twitter, and among it seems to be asking, among other things, for whether ChatGPT or whatever other products they have would generate statements about persons. Can you explain the gist of that, or what is the regulatory authority of the FTC that civil investigative demand is being issued under?
So as a general matter, some of the concerns that we're seeing in this AI space is that ChatGPT and some of these other services are being fed a huge trove of data. Right. There are no checks on what type of data is being inserted into these companies, and we've heard about reports where people's sensitive information is showing up in response to an inquiry from somebody else. We've heard about, libel, defamatory statements, flatly untrue things that are emerging. That's the type of fraud and deception that we're concerned about.
So as a general proposition, and you just said something, you spoke to libel and slander or defamation issues, and I'm going to come to that because that's an issue of state law as I understand it. But is your regulatory reach there defined by, the FTC Act? Is that the basis under which you guys investigate that stuff with a company like OpenAI?
So it's absolutely true that we don't directly address those things. We're focused on, is there substantial injury to people?
Yeah.
Injury can look like all sorts of things.
So and you were speaking earlier in communication with the chairman or your colloquy with the chairman about the Twitter background of releasing private information. Was that also subject to your regulatory reach under the FTC Act because it was somehow deceptive? Or is there some other statutory source that generally puts you guys in charge of, sensitive information about people?
Yes, it's the FTC Act that prohibits unfair or deceptive practices and unfair methods of competition. That's primarily the authority we've used in these instances.
Okay, and that, that's interesting. And just for the people in the public, the operative language of Section 5 that you guys, I think, are using there and in the context of the non-compete rule that you've come out with, it just says, unfair methods of competition in or affecting commerce and unfair or deceptive acts or practices in or affecting commerce are hereby declared unlawful, right? That's the language?
That's right.
Yeah. And so it's not really very detailed. Let me ask you for a minute about the non-compete rule. So you guys have this proposed rule you're seeking comments on, administrative process, then once those comments are reviewed, you guys will decide, the FTC will decide whether to proceed with the final rule. Is that the way it works, basically?
That's correct.
And so in that case, I litigated these kinds of contracts in state law for 30 years and in North Carolina. I know California has a rule that absolutely bans them. They're different renditions of law, some statutory, some made by the courts over time in states all over the country, and there have been for a long, long time. So what your rule would do would displace all of that state contract law in one fell swoop if it were made final, wouldn't it?
It would create a new floor, yes.
It would create a what?
Yes, it would be creating a new provision that would be determining that these non-competes are ruled unlawful.
So you would not only, and it would be per se. It wasn't. I know some of the stuff stated in your notice of proposed rulemaking that I've glimpsed said it would be, that you saw these as inherently coercive or the product of unequal bargaining power, but the rule would be per se, except for a very narrow category, or the overwhelming majority would be per se, even if the people involved in those contracts wanted to make them, right?
That's the proposal. We did ask as part of our notice of proposed rulemaking some questions about whether there are adjustments we should make.
And I don't want to get into the minor details because we only got about 30 seconds left. Let me just ask you this, because if you take that example, or many of the others have been talked about. You spoke a moment ago about being concerned about concentrations of economic power. I get that. Isn't there a basis to be concerned about concentration of legal power, law-making power? So you got 30,000 state judges have made those rules. You got 7,558 state legislators. You got lots of members of Congress. You got multiple chambers in Congress. The fact that you really, as the, a bare majority on the FTC, could make such a ruling, isn't that something that Congress should be concerned about, how much power you wield?
So we make these determinations pursuant to authority that Congress has given us. When we promulgate rules pursuant to the Administrative Procedure Act, there are a whole set of procedural protections that go into play relating to the comment periods that we have to use to get public input. There are certain standards of review for judicial review. There are so many checks as part of this process, and it's really quite regular for administrative agencies to be engaging in rulemaking.
But you get to say what's unfair, right?
So interestingly, Congress, when passing the FTC Act, was having a debate. They said, should we actually define, should we list out in the statute all the practices that should be unfair? And Congress determined, businesses are so innovative, they'll find ways to do an end run around any of the practices we list. Let's allow the FTC to use their expertise to make sure that as markets are evolving, as business trends are evolving, that they can make sure that their statutory authority is keeping pace. So this was a determination and a decision that Congress made to use that language, and we follow the text of the law.
Thank you, ma'am. I wish I had more time. Yield back.
Recognize the gentlewoman from Vermont.
Thank you, Mr. Chair.